Part of those facts accurate?
Yes, Your Honor.
Did you get into an argument and into a fight with SB?
I don't believe so.
You don't think you did?
I just know that when she dropped me off, she was yelling stuff at me when I drove.
The video begins with what sounds like a routine check, the judge simply confirming facts. But listen closely. The defendant hesitates, stumbles, avoids giving a direct answer. Is it just nerves? Or is he trying to downplay something bigger? In court, even silence and hesitation can speak volumes. What do you think? Is this man just nervous, or is he hiding something?
Provoke a disturbance?
No.
Good, we're going to trial. Thanks. We'll set this matter for a trial. Okay? We will go on the record in the matter 24 CM 202, State of Wisconsin versus Andrew Koch. The state appears through Assistant District Attorney Holly Rockow in person. Mr. Koch appears in person in custody with counsel Joel Beliski. We're set today in this matter for a plea and sentencing hearing. The parties have reached an agreement. Mr. Beliski, can you please recite the agreement for the record?
The questioning continues. The defendant insists he didn't provoke a disturbance, but the judge isn't entirely convinced. Soon after, the case is officially called State of Wisconsin versus Andrew Koch. We learn he's here for a plea and sentencing hearing. At first glance, it looks like a straightforward deal. Plead guilty to one misdemeanor, pay court costs,
and this case is about to show us exactly how.
But quick deals often
Yes,
hide
Your Honor.
deeper
Mr.
layers.
Koch has agreed to plead to one count of misdemeanor disorderly conduct, with the remaining counts in the complaint dismissed and read in, and a joint recommendation by both parties for court costs totaling $443.
And I believe he was in the process of a revocation. Was he revoked or did?
Yes, Your Honor. As of yesterday afternoon, the final decision from the administrator came in, and he has been revoked, and he will be sent to Polk County for sentencing.
Okay. And what charges was he convicted of in Polk County?
I believe they were substance use related, Your Honor. I was not originally opted into that case. That was my predecessor, Mr. Pollack. Unfortunately, I cannot speak to any detail as to the nature of those charges.
All right, thank you. I can just pull it up. I just am curious. Would it be for the 24 cases or for a 21 case, Mr. Koch?
24?
Oh, 24 case. Okay, so for the 24 cases.
This is where things start to unravel. The charges in Polk County: possession of amphetamines, cocaine, repeat offenses. That's not a one-time mistake, that's a pattern. And in criminal law, patterns matter. They build a profile, a narrative the court can't ignore. So why, despite these serious charges, is this case being handled so gently? Hang tight.
Possession of amphetamine as a repeater. Possession of cocaine, a misdemeanor.
The prosecutor outlines the agreement: plead guilty, pay $443, and avoid bigger charges. Sounds light, right? But then we learn more. In another county, Koch already faces drug-related convictions: amphetamines, cocaine, repeat offenses. That's no first mistake. That's a pattern. And in law, patterns matter. So why is this case being handled so gently? Do you think repeat offenders should get plea deals this light?
This is it, the moment that shifts the entire courtroom atmosphere. The victim Espias about to speak. Her voice will cut through the dry legal language, the plea deals, the court jargon, and what she's about to say. It changes everything. If you've been waiting for the emotional heartbeat of this case, this is it.
I was in a relationship with Andrew Koch for almost a year. Since we started dating on January 22nd, 2024, I knew there was something wrong with the way he would talk to me or even act. But I was in love. On April 5th, that's when the real anger started. Almost every day from then until the 22nd of October, or the 21st of October. There were fights. He would hit me, but he always thought that he could just make it up. Sorry. On October 21st, we were at a friend's house, and he was on the phone with a friend, and just out of nowhere, he called me the B word and then threw a car manual at me. Seconds later, he would spit in my face. But once again, made it up, told me he would never do it again. But just a couple hours later, my world flipped around. On October 22nd, about midnight, we left the friend's house and he drove to a parking area in Grantsburg. I ended up falling asleep in the passenger seat, like I always had. He ended up waking me up to ask me where the drugs were. I handed him what he had wanted, and I went back to sleep. He woke me up again and asked me for the other bag. I said I gave him everything I had, and I didn't have anything else. He got angry and started firing the flare gun out the sunroof. The second time he woke me up, he asked me once again, and I told him the same thing I had told him the first time. This time, he got mad at what I had told him, and he ripped off the rearview mirror and threw it in the back seat. Then he took the passenger visor and ripped it off the car, and then hit me in the cheek with it. The third time he asked, I told him the same thing. This time, he ripped off my glasses, bent them, and broke them.
This wasn't just abuse. This was psychological and physical terror over months. Broken glasses, ripped phones, smashed mirrors. Every object turned into a weapon. Every moment, a new method of control. And all while she's trapped inside a car with nowhere to go. This isn't just disorderly conduct. This is survival against an escalating threat.
So I thought I was going to try and call for help. He ended up taking my phone and with his two hands, literally ripped it in half.
Then the atmosphere shifts. The victim, SB, steps forward to speak. Her voice pierces through the courtroom silence. She describes months of abuse, insults, spitting, flare guns fired out the car, broken glasses, smashed phones, and finally, her head slammed against a window. Every object became a weapon. Every night became survival. This isn't just disorderly conduct, this is terror.
And they were black. It was like Andy was gone and someone else took over. The next thing I knew, he started bashing my head against the passenger window. And all I kept thinking was, I have to get away, otherwise he's going to kill me. So I had got him calmed down enough to where he would drive to Dollar General where the van was parked. We were going to move it, but we decided he didn't want to because he was getting tired. He let me drive the car, and I knew that was the only way I was going to get out. I drove the car to the Frederick Trailer Park, where I knew I would be safe. I parked in the front entrance and stopped. He woke up and started yelling, calling me every name in the book, but I was only able to grab my purse, and that was it. I started walking to my friend Jen's house in the park, and I got there and she asked me if she could call, and I said yes, and fell to the ground. The cop from town came, and my body started going numb. I ended up throwing up and passing out. Not knowing what was going on, they called the EMTs, and I went to the hospital and had a CT scan. Your Honor, this is still painful for me. I have anxiety and panic attacks now, every day. I am actually on nightmare medicine. I don't know the name of it. But I have nightmares every night, every time I sleep, of what he did to me. I am in therapy almost either 1 or 2 days a week, and I will be on therapy for at least 3 years, she said. This was 6 months ago, and yet it still gets to me every day. I don't know how I'm going to move on from this. So I'm asking you for some stipulations. 90 days in jail, no contact with me, my property, or my roommates, no possession of firearms, anger and drug treatment, and probation.
6 months later, she's still reliving it. Daily panic attacks, prescription medication for nightmares, ongoing therapy, and all she asks for is 90 days in jail and no contact. Think about that. She's still in mental prison, while the system considers letting him walk free with court costs. If that doesn't make you pause, rewind and listen again.
I don't think it's fair that I have to live with this every day and he would get away scot-free. He has made it to where I don't feel safe, and I will be putting 2 restraining orders on him for both counties.
She breaks down the lasting trauma, panic attacks, nightmares, daily therapy. And what does she ask for? Just 90 days in jail and no contact. Imagine that. After months of violence, she isn't asking for revenge. She's asking for safety. That's the difference between the victim's reality and the system's paperwork. If you were in her place, would 90 days sound like enough justice?
That expose how fragile justice can be when the full story stays untold.
The complaint is very sparse and just indicates that there was an argument and it may have escalated, but what I have access to doesn't discuss the level of what that argument may have been or consisted of. All right, so then the agreement, Ms. Rockow, now again, after hearing the victim, what is the basis for the agreement in the justice or in the public interest?
Well, Your Honor, I think some of that information wasn't information that the state had when this case was charged or when this offer was made. It's not my file, but from my review, I didn't happen upon that, what was described just now. So based on the facts that are contained in the criminal complaint.
And again, and I'll state, you're probably hearing or seeing it for the first time as the court is, because the criminal complaint is one small little paragraph that just describes a fight that occurred and that it may have escalated a little, but none of the detail.
Right. But Your Honor, again, Mr. Koch has been revoked in Polk County on some more serious charges and is going to be presumably serving a jail sentence. I think at least one of those had some stayed jail time. So I think that he's going to remain in custody for a while. I don't believe that based upon the facts, that anything more is necessary here. I think that the bail jumps, again, were associated with the Polk County cases. So I don't consider that to be, of course, he violated his bond. But I think that the focus here in Burnett County should be the disorderly conducts. And I don't think that any jail or probation is appropriate. I do think that costs only is sufficient to protect the community.
Prosecution is squirming. You can tell this isn't what they expected to hear in open court. They made a deal without the full story, and now, in real time, they're realizing it. But here's the problem. Plea deals are like signatures and ink hard to undo. The question now is, will the judge let this one slide or call for something strong?
All right, and my guess is that the state wasn't aware of I'm going to guess also maybe the police.
Here comes the shocker. The judge admits the criminal complaint barely mentioned anything. No broken glasses, no head bashing, no flare gun, just an argument. How does a case this violent get reduced to disorderly conduct?
But here's the problem.
It shows how
Plea deals
fragile
are like
justice can be when only part of the story is told. The prosecutor squirms, realizing the deal was made without the full truth.
There is no state jail time. That was that fictitious thing that some judges do, and they fictitiously say, I'm having that fictitious conditional jail for probation to use if they wish to do.
Understood.
And so with regards to the charges in Polk, he does have the possession of amphetamine with the repeater. So that means the maximum possible penalty of 1 year he could face, with the increase of no more than 2 years for that underlying misdemeanor in Polk County. But that's for Polk County to deal with and for you to deal with in Polk County. And you were under bond conditions in Polk County when you violated your bond here by engaging in the criminal actions here in Burnett County. And for the record, and this is, I guess, for the victim as well as you, Mr. Koch, for you to be aware of, and perhaps the reason why these were simply charged as disorderly conducts is because of the little bit of information that was provided the day of the incident, at least that I have in front of me. And usually what's in the criminal complaint is what has been provided to the police in the police report. So there's not much. This is the first time that I believe perhaps even the state is hearing the depth of what may have occurred that night. So he's pleading guilty to one count of disorderly conduct, is that correct? And the other count will be dismissed and read in, and he's facing the other charges in the bail jumps in Polk County?
To my understanding, Your Honor, that is correct. It's a plea for one count of disorderly conduct, with the remaining counts in the complaint to be dismissed and read in. As has been stated, he has been revoked from probation, and he will be sent to Polk County for sentencing after revocation. I would like to take note that he has been in custody on this revocation hold stemming from this incident since October 31st of 2024. He has accumulated approximately 155 days of jail credit. The conduct has, again, prompted revocation here, in the maximum sentence for a charge of disorderly conduct has been vastly exceeded. He's set for close to double the amount of time he would for the maximum sentence on this. The public, I believe, has been sufficiently protected. He will continue to reside in custody, awaiting sentencing after revocation. I believe he will be returning to active supervision for his Polk County charges as well. In entering this plea, he is taking accountability for this and does wish to move on. For those reasons, I would ask the court to adopt the joint recommendation. Thank you.
All right, can I have the plea questionnaire waiver of rights form, please?
Yes, Your Honor. May I approach?
You may.
The judge reviews Cody's other cases in Polk County, noting he's already revoked on probation there. But still, the state argues for costs only. No jail, no probation, just $443. Imagine hearing the victim's detailed testimony and still calling that sufficient. Even the judge questions why battery wasn't charged in the first place.
Conducts and 2 bail jumps. That sounds good to me. So maximum possible penalty for 2 disorderly conducts, up to 90 days of incarceration, and for 2 bail jumps, up to 9 months each. Because if you're indicating you didn't do it, and you're indicating that.
Then comes the twist. After agreeing to plead guilty, Cody backtracks. He denies provoking any disturbance. He denies fighting. In one breath, he risks the entire deal. The judge doesn't hesitate. No more sweet offers. This case is going to trial. Sometimes denial is a gamble, and this time it backfired. Do you think he was bold or just reckless?
I'm available that day, Your Honor.
Excellent. So we'll have a trial on June 24th. That'll be a trial because, again, if you didn't do anything that day, that's what your assertion is here, Mr. Cote. The state has to prove it beyond a reasonable doubt that you engaged in any type of conduct that would be disorderly, and whether or not you were on a bond in Polk County and whether or not you violated that bond, and you did so knowingly. So that's what we're going to do. June 24th, we will have a trial. We only need one day. That works for victim, Ms. Bauer?
Yes, sir.
Excellent. Now let's get to my final drop dead date. That means, Mr. Cote, that is the day that I will no longer take any type of agreement, okay? I won't accept any agreement in this case, all right? And so that means the matter will go to trial, and you will be able to have your attorney state your, or actually have it'll be the state trying to prove the case, and your attorney will be able to defend you and your claims at this matter. But on May 29th, that'll be the last day, the drop dead date for any agreement that'll be reached. And quite honestly, to me, the court does not find a disorderly conduct.
And the judge makes it clear this case will go to trial unless something major changes. No more leniency, no more costs only. After hearing that victim's raw emotional statement, the judge draws the line. The system may have missed the mark at first, but now it's time for accountability.
With costs only, especially hearing the statement from the victim to be in the public interest. So let's do May 29th, Mr. Feliski, May 29th. Well, you said that this is going to be a Schmidt, even though it's on that. So let's do May 19th.
The trial is officially set for June 24th. The judge lays it out clearly. No more leniency, no more plea deals after May 19th. If Cote wants to claim innocence, the state will prove its case in front of a jury. The victim will testify, and this time, the full story will finally be on record.
Recommendation from both of the counsels, both of the attorneys here, a joint recommendation for costs only. That would be court costs and DNA surcharge, etc. Costs only for $443. Do you understand that is simply a recommendation to the court?
Yes, sir.
Said differently, that means I'm not bound to follow that, and I could sentence you all the way up to the maximum possible penalty, and I could do that here today if I thought it was necessary and warranted. Do you understand that?
Yes, Your Honor.
Do you still wish to proceed and enter a guilty plea?
Yes, Your Honor.
Did you go over the criminal complaint with your attorney?
Yes, Your Honor.
And again, that's that.
This courtroom hearing shows how easily justice can get clouded by incomplete reports and plea bargains. On paper, it looked like a minor disorderly conduct case. But once the victim spoke, the real depth of violence and trauma was exposed. In the end, the defendant's own denial forced the judge's hand, pushing the case to trial, where the truth may finally come to light. Cases like this reveal the cracks in our justice system. Do you think the judge made the right call by sending this to trial? Let us know in the comments. And if you found this breakdown eye-opening, don't forget to like, share, and subscribe for more real courtroom stories that uncover the truth behind the drama.